Supreme Court Special. It's another Supreme Court Special. Every single story. Were they right? Were they wrong? Man, are they just dumb? Find out in the Supreme Court Special.
As bad as they were on the Fifth Amendment, they did a really good job with the Fourth in Chatrie v. United States. Okay, so dude robbed a bank. Like, who does that these days? And police collected all the cell phone location data in the area to locate the perp. They applied to Google to hand over the data on every cell phone within a 150-meter radius of the credit union, including all customers, employees, and bystanders in a 3-block radius. So Google dutifully handed over everyone's private location data, including that of Okello Chatrie, who just wandered into the Geofence and left immediately towards a residential area. Before 2018, our cell phone data wasn't protected. Then, the Supreme Court ruled in Carpenter v. United States that cell site location data is protected and needs a warrant to access under the Fourth Amendment. So Chatrie fought to have the Geofence evidence suppressed. But although the lower court found that the warrant violated the Fourth Amendment, they allowed it anyway under the good faith exception. Basically, officers can behave as horribly as they want as long as they believed in their hearts it was valid. On appeal, an en banc Fourth Circuit panel tied 7-7. Now, the Supreme Court majority found that it was a violation of the Fourth Amendment. Alito, Thomas, and Barrett dissented. Sorry, no Kluans for them. Justice Kagan wrote for the majority,
"The government is wrong about the incapacity of short-term location information to reveal private matters. Repeated patterns in the government's phrasing are not all that individuals wish to, and reasonably expect to, keep to themselves. Return here to another of Jones's insights. Even short-term monitoring of a person's physical movements can provide a wealth of detail about his familial, political, professional, religious, and sexual associations."
We've shown that in the past. On the 7 September 2015 podcast, we show how people were able to use Australian reporter Will Ockendon's metadata to conclude all sorts of things about his life, and also come to some false conclusions as well. Kagan wrote,
"Still more fundamentally, we have never understood Fourth Amendment protections as kicking in only once an intrusion goes too far. Where the Fourth Amendment applies, it applies regardless of the quality or quantity of information the government obtains. So, for example, this court held that thermal imaging qualified as a search, even though it did not, and was not likely to, detect private activities or intimate details.
And it was only that narrow because Google insisted on it. They wanted to hand over as little information as possible. Had it been up to law enforcement, they would have gotten a lot more.
For all those reasons, we hold that police officers invade a cell phone user's reasonable expectation of privacy when they access his location history. It does not matter if the time period scrutinized was only 2 hours, nor does it matter that the materials obtained were handed over by a third-party tech company. When the government accesses historical cell phone location information, location history as much as CSLI, it conducts a search under the Fourth Amendment.
They didn't throw it out entirely. It's up to the Court of Appeals to decide whether that search was reasonable and supported by probable cause. But now they have to actually make that assessment. Law enforcement doesn't get a free pass. Let's take a quick look at Alito's dissent, though.
8 years ago, I warned that this court's decision in Carpenter v. United States would produce one of two outcomes. Either the court would need to clarify Carpenter's limits in a future decision, or Carpenter would usher in revolutionary developments in our doctrine by giving criminal suspects a protected Fourth Amendment interest in any sensitive personal information about them that is collected and owned by third parties.
You say that like it's a bad thing. Well, I don't want to dwell on the bad. This is a good decision, and 6/9 of the Supreme Court deserve this shiny new silver Kluan.